People are asking, are the Sharia courts operating during PKP? Because the civil ones are to a certain extent. So kalau macam, actually, for example, yesterday there was a moot filing, fast track, everything online. Application in the morning at 8 a.m. and order in terms by 10 a.m. and order extracted by 12 p.m. Is that happening? Is that a possibility during this pandemic? In fact, is it an available option without the lockdown as well? Are the courts operating, Yang Ahmad Arif?
Okay, Aisha, if you can still remember when we had the first MCO, the judiciary was not classified as essential service, right? So what we did in the Department of Sharia Judiciary of Malaysia in April, we wrote a formal letter to MKN, Majlis Keselamatan Negara, to classify Sharia courts as essential services. We submitted to them SOP, okay? We submitted to them SOP, and our SOP had also been approved by MKN. So in other words, from April 2020, Sharia court have been operating, Aisha. Of course, with limited cases, okay? Because we want to strike a balance between the safety of the parties, safety of the judges, court officers and staff, okay, and also the peguam syar'i. So we have to strike the balance, and of course ensuring the access to justice. So since April 2018, we have been operating the Sharia court with limited SOP. I think one thing that differed Sharia court with the civil court, I think, is with regard to the virtual hearings, right? I think last year in September, when the civil court managed to amend the rules allowing virtual online or online hearing, we wanted to amend section 119. Aisha, section 119 pertains to trial. So there is no provision allowing the Sharia court specifically to conduct online trials. So we do not have. So we wanted to amend section 119. When the civil court managed to amend it, we are still struggling because when we presented to Jawatan Kuasa Teknikal, Civil and Syarak, they said that we cannot continue without finding or without ensuring whether online hearing is in line with the Sharia principles or not. So we have to seek ruling from Jawatan Kuasa Fatwa first. No, if you ask me, Aisha, Liza, you ask me, that's why when we presented to Jawatan Kuasa Teknikal, we straight asked them the permission to amend the law, because I believe that there's no question, because this is online hearing is something which, I mean, you see, what is important is to allow access to justice. Yes. That is the Sharia. How you do it is a question of ijtihad. So this is what we believe. But of course, that we are subjected to certain committees. So we have to respect the committee's view. So now we are still, because there's so many committees that we have to go through. We have to go through and present it. Okay, but so far the two committees that we presented, they agreed with us, JKSM, that online virtual hearing is in line with the Sharia principles. Okay, so there's only one committee that we have to go through. So once we get the ruling from those three committees, then only we can proceed in amending the section 119 to allow the Sharia court judges to do online hearing. But Aisha, we do not wait until we get the ruling. So what we have been doing since April 2020, we sought agreement by the parties. So through agreement by the parties, so whenever the parties agree for the application to be heard online, then we proceed. So most of our judges sought the agreement by the parties as a source of what do you call
moving
it?
Forward.
Yeah.
To move forward, yeah.
That's right. Because
the interim.
Exactly, Lisa. So we do not know when we will get that permission. Okay, to amend section 119.
Right. Sorry, can we just go back to earlier when we were talking about talaq? Can I just clarify that a witness is not a requirement, right? So witness is not a requirement for the lafaz.
Liza, we have a particular case. That case is known as Zainab binti Mahmud. You know, in that particular case, Muhammad Yusuf, the husband pronounced talak in the absence of the wife. He alleged that he pronounced the talak in the presence of one ustazah dekat pejabat agama. Okay, this is what his allegation is. So in other words, Zainab's husband went to the Sharia Court of Selangor alleging that he has already pronounced talak. At the lower court, Liza, without calling the witness, the court decided to confirm the talak as alleged by the husband. The matter was brought before Sharia Court of Appeal, Selangor, and Court of Appeal has reversed the decision. The court said it was wrong for the judge to confirm the talak by mere allegation by the husband. So in other words, you can see that it is still incumbent for the husband to prove his allegation. What happened? I'm telling you that
so it's not automatic.
That is the ruling by the Sharia Court of Appeal. What more, you see, Liza, it would be detrimental to the wife. For example, okay, you see, if the husband were to deny the wife the right to areas of maintenance, he would simply allege that he has already pronounced talak 10 years ago. Yeah, so if the court confirms the talak, Liza, then that the wife would be completely deprived of her right to claim for areas of maintenance for 10 years, because the husband will say that, oh no, you cannot claim for nafkah because 10 years you already been divorced. So it would be a great injustice for the court to simply accept the allegation by the husband that he has actually uttered the word divorce. So in that sense, you can see I'm giving you a court case, okay, what the ruling by the Sharia Appeal Court, okay.
Going back, Yang Amarif, the many issues come out of this. I'm looking at the perspective the wife, isteri. What if after Section 47 the husband files, and then later on he denies the intention, he denies uttering the talak, even though that he might have given an email or WhatsApp to the wife. And secondly, I guess in favor of protection the wife, and the wife wants to rely on it after all, wants the divorce to go through. And secondly, if under Section 57 the wife files for divorce, okay, 7 days have gone past, or the wife wants to file for divorce anyhow, and the husband doesn't take her seriously, what are her rights? I say it's an abusive relationship, I say dalam PKP, hari-hari asyik kena belasah lah, macam-macam mentally, physically, what are her options then as well?
Aisyah, with regard to wife filing an application under Section 57 and the husband denies it, of course, as I said to you, divorce sent by SMS falls under the second category. So it still requires the husband's intention. You know, in Sharia courts, of course, the burden of proof lies on the wife, because the wife, she managed to bring the evidence. But again, it still requires the intention by the husband. So the court still needs to ask him. Now, we have another form of evidence known as yamin or sumpah. If the husband wants to deny it, it would not be mere denial like that, Aisyah. Most of the Sharia court judges would require the husband to deny it by way of yamin. So in other words, you see, I've got many cases, Aisyah, before me. Whenever that we ask the husband kan, kita kata suruh dia bersumpah kan. But before we ask him to bersumpah, then kita akan explain to him the nature of the sumpah, the nature of the yamin, consequence of the yamin, Aisyah. So in other words, saya pernah ada satu case kan, I told the husband, you see, some of the Malay, they very strong, they like to do sumpah. Oh, dia kata okey lah, ya Arif, saya masuk, saya berani untuk bersumpah. Dia pergi ke depan kan, dia move forward to do the sumpah. I said, cik, tunggu sekejap, sumpah, biar saya terang sekejap tentang sumpah ni macam mana, apa kesan dia, apa sumpah. Saya cakap, cik ingat tak, pernah dengar tak cerita orang apa ni, jalan-jalan tiba-tiba kena panah petir apa semua tu kan. Dia kata, itu kadang-kadang tu yang bermain dengan sumpah. You know what happened is, bila dia dengar macam tu kan, then start to backtrack, kata tak berani nak tu. So at least kan, Aisyah, in order for us to ensure kan, because you do not know, it's basically in their heart. You can gauge whether he speaks the truth or not. But at least when it comes to Sharia court, there is another form of evidence that we can tell the husband, kan, if you decide to do the sumpah to deny it, and you know the consequence, and you know whether you intended or not, you know yourself. But if you do the yamin, you say in the name of Allah, wallahi wa billahi wa tallahi, and you know that you were not telling the truth to the court, and these are the consequence. I don't know, but most of the cases before me, they retracted. Dia tak berani, Aisyah. I don't know. That's my experience. Tapi kalau dia nak menipu juga, dia tak tahulah. Sebab kalau orang yang betul-betul berani, then akan
right.
we cannot do anything.
Understood.
Ya, Arif, apakah situasi sekiranya suami lafaz talak sebab dia rasa tertekan? Masa MCO ni ramai tak ada kerja, duduk rumah, satu rumah, and then tengok muka hari-hari, tengok muka sama, and then dia rasa tertekan, ataupun isteri dia meletih ke, and then dia lafaz out of anger, out of stress. So apakah situasi talak tersebut?
Itulah Liza, dia kalau katakan lafaz suami tadi tu dalam keadaan dia hilang
tak ada niat,
sanity tu, dia kalau kata lafaz yang dia sebut tu Liza bukan yang berbentuk talak, cerai, then like I explain, that mere pronouncement that one kan talak dah jatuh, whether you intend or whether the husband has intention or otherwise. Tapi dalam kes ni memang dia keluar perkataan cerai tu Liza, tapi dia memang tertekan sangat, kewangan, isteri dah marah semua tiba keluar tanpa dia sedar. Tak, sanity tau, dia hilang sanity, dia tak sedar langsung perkataan yang dia keluarkan tu, dan dia tak faham pun, tiba-tiba saja terkeluar. That would not be considered as valid.
So following on from that, just now tadi yang Arif ada cakap kan, rujuk tu only can happen, boleh terjadi selepas lafaz cerai, selepas cerai lah, in the 100 days. So does that mean maknanya sebelum ke mahkamah dan memang dah ada lafaz cerai tu, lepas tu couple tu nak, basically what I'm trying to get up is they want to rujuk tu, nak rujuk, tapi what comprises rujuk exactly?
Okay.
And then what happens if the husband nak rujuk tapi wife does not agree pula?
Okay, Aisyah, there are two situations under the law. Okay, the law says rujuk within 100 days tu, it must be done before pejabat agama. There are two separate institutions. One is Jabatan Agama Islam, another one is Syariah Court. These are two different departments, okay, in the state. So the law says if the both parties, husband and wife, after the husband has already uttered the word talak, they want to rujuk within that 100 days, then it must be done and registered and recorded by pegawai pejabat agama di Jabatan Agama Islam. So if both parties consent within the 100 days, then it is pejabat agama. If it is within 100 days or beyond the 100 days, but one of the parties does not consent, macam Aisyah tanya tadi lah, wife does not consent to the rujuk. Then question is, boleh tak suami unilaterally revoke the divorce without the wife consent? No. The law says we have to differentiate what the law provides, Aisyah, in the law. What the law says, in order to ensure justice to the wife, in order to respect the right of the wife who has already been divorced by the husband, the law says it must be consented by the wife. That what in the law. So I'm talking from the legal position. So for as long as the wife does not consent it, then it cannot be registered di pejabat agama. So it has to go to the Syariah court. Then it is the burden lies on the husband. So the husband needs to prove to the court that the rujuk is valid. Okay, because the wife does not agree. So if the law also says whenever the wife has not consented to the rujuk and the court finds that there is possibility that the parties can be reconciled, then both of them will be referred to a reconciliatory committee.
Yeah.
So to conclude your question, Aisyah, basically the law requires the consent of the wife. Okay? So it cannot happen unilaterally under the law.
Yang Arif, you mentioned about another department apart from the Syariah courts. There's a question about the JKP, soalan tentang JKP, Jawatan Kuasa Pendamai. Are they also limited within section 119? Can it be done virtually? That's one question from the audience.
I'm not sure what is the SOP of the religious department. I can tell you if it is within my jurisdiction and my power within it, within the Sharia court. Why? Because once the court has constituted a reconciliatory committee, which is going to be chaired by an officer at the religious department, then I think the religious department, the officer will then be subjected to their SOP. So I'm not sure whether that religious people would allow any proceeding, any meetings to take place, because a reconciliatory committee will be headed and chaired by an officer at the religious department.
Yang Amat Arif, we will move on. Boleh tak yang Amat Arif terangkan apakah status anak yang a child that is conceived out of selepas talak dilafazkan. Let's say the husband sudah melafazkan talak, lepas tu the wife was found pregnant lah, ya Arif. So what is the status of the child?
Okay. Then you see, for as long, to me, okay, for as long as the court has not confirmed, under Section 47 is going to be a formal one. I don't foresee, okay, where parties do not know or the wife does not know. Your question maybe relates to the Section 57, the possibility. Okay, what the wife is not aware, that the husband has already pronounced the talak. So to me, and I think the rulings of the Sharia court for the wife and also especially the children, they cannot be blamed, okay, for actions done by the husband, suami tadi tu. Sebab itulah saya katakan tadi, when the matter is tested before the Sharia court, the court will also look into the welfare of the children. So we cannot simply say that the child is illegitimate, anak yang tidak out of wedlock, because the court will still need to look into when there is what we call this dalam keadaan yang syubha, the benefit of doubt will always be given to ensuring the welfare and the benefit of the children. So the court, the child.
Okay.
Arif, I think there was a question. If let's say there is a child out of wedlock, usually you cannot binkan nama bapa dia. Tapi what is the position of the father to maintain this child?
Okay.
Does he have an obligation to maintain his child which was born out of wedlock? I think that's the question.
Liza, I think this is one of the provisions I think we have to look at. I'm telling you about the current legal position. The current legal position with regard to obligation to maintain an illegitimate children, the law clearly says it is obligation of the mother. That's the reason I'm telling you that I think this is one of the provisions that we need to look at, because our worry is that the irresponsible men, they will go and make children. They produce children without any obligation, and the obligation to maintain only lies on the women or the mother, because the law says so. Okay, I think that what we need to do. Alternatively, Liza, I think there is also in the law which can be used. Okay, there's a particular section which if both of them, for example, if they decide to marry, okay, the situation if they have illicit intercourse, okay, and the children were born due to zina, and for example, and then later on they decide to marry, so they can become husband and wife. So in that particular situation, to me, there is a provision which allows or put an obligation on the father who regard anyone yang berada dalam keluarga tu sebagai anak dia, jadi tanggungjawab tu pun berada pada dia. So I that particular provision can also be invoked, Liza, so as to put an obligation on the biological father. Apa yang ada lakuna tadi tu ialah kalau if they decide not to marry, then what that will be difficult for any specific provision that obligates the man from the responsibility to provide allowance or maintenance. Okay, alternatively, if we do not use the word nafkah, for example, maintenance or sustenance, we can use other words like allowance or anything to put responsibility. There's a financial responsibility on the part of the biological father.